My Lords, may we go to tab 8 of the authorities bundle to the case of re O&M and to paragraph 31.
Yes.
At paragraph 31, this is the speech of Lord Nichols. In on certain perpetrator cases, the judge says, the correct approach must be that the judge conducting the disposal hearing will have regard, to whatever extent is appropriate, to the facts found by the judge at the preliminary hearing. Nowadays, the same judge usually conducts both hearings, but this is not always so. When the facts found at the preliminary hearing leave open the possibility that a parent or other carer was a perpetrator of proved harm, it would not be right for that conclusion to be excluded from the consideration at the disposal hearing as one of the matters to be taken into account. The importance to be attached to that possibility, as to every feature of the case, necessarily depends on the circumstances, but to exclude that possibility altogether from the matters the judge may consider would risk distorting the court's assessment of where, having regard to all the circumstances, the best interests of the child lie. Similarly, and for the same reason, the judge at the disposal hearing will take into account any views expressed by the judge at the preliminary hearing on the likelihood that one carer was or was not the perpetrator or a perpetrator of the inflicted injuries. Depending on the circumstances, these views may be of considerable value in deciding the outcome of the application, for instance, whether the child should be rehabilitated with his mother. It is that phrase, my Lord, the likelihood that one carer was or was not the perpetrator below the civil standard that we say if one is going to apply the blue pencil test, that is where it should fall. And to complete the...
Sorry, would you just say it again? I didn't quite follow that.
We talked about the blue pencil test before lunch, my Lord, and we said that if one were to apply...
This is blue pencilling part of this reasoning as being wrong.
32, paragraph 32.
It's not really reasoning, is it? Because it's guidance on the conclusion that he reached in relation to the actual outcome of the case.
The danger, this is where the problem arises in our submission, is this concept of likelihood that one carer was or was not the perpetrator at a standard below the civil test.
You would substitute for that something like views expressed on the risk factors identified at the hearing which attach to either of the parties.
Well, in fact, we don't need to substitute it because, in fact, Lord Nichols goes on to express precisely those concerns, and we say that one could simply almost remove paragraph 32
yes.
And the coherence of the whole stands.
What about paragraph 31? Is that happy?
Well, if it's a genuine don't know case,
Yes.
you can't possibly exclude it from your mind.
As we've seen in Re D, there will always be cases where the judge will not be able to identify a perpetrator, and there's nothing in paragraph 31 that offends that.
But if you do...
It's always a possibility.
Sam says...
So I'm just trying to get clear. In cases where you can't make up your mind,
Yes.
then you do mention the possibility. You may
No.
mention the possibility.
No.
In case, no.
No.
Well,
When on the application of the civil standard of proof, the judge cannot identify a perpetrator, on that issue, we agree with Lord Justice Thorpe, safer to leave it thus. Safer to leave any questions of likely perpetrator to one side and assist the assessment process only by highlighting those features of the evidence which the judge, having heard the evidence, thinks will be pertinent to the assessment and should perhaps focus.
What is that? What's Lord Nichols saying in paragraph 31?
Well, is he saying, really, my lord, any more than the fact that there will always be cases where the court has to leave open the possibility that a parent or carer was the perpetrator of harm? They remain in the pool of perpetrators, but they are not identified
So in this case, the judge would leave the mother in at the present moment. But I mean, supposing the judge says 70% father, just supposing after he said that, 30% possibility mother.
Yes.
Does paragraph 31 give any guidance in that situation or not?
No, it doesn't.
No.
But this is Lord Nichols speaking, the architect of the heightened cogency test, and we say just as it is logical and rational for Judge Kushner to take that test and apply it, so it is for Lord Nichols. But to start looking, as the judge says here, when you cannot find a perpetrator, at concepts of likelihood, we say is a recipe for disaster.
Why don't you argue that 31 should be taken out as well as 32?
Well, perhaps it doesn't need to stay. It's not as offensive as paragraph 32.
Well, except that it's part of the ratio, is it?
Well, of course it is, but it's just rather confusing. I find that even the use of possibility there rather disturbing.
Well,
you see, I think a moment ago you said he
Yes.
can leave in, or the judge she can leave in the factors which she regards as relevant to the assessment.
Yes.
I absolutely understand
Yes,
that,
right.
and those are set out seriatim. One can pick them up and put them into play, given that one's already got a finding on the probability, the balance of probability test, which is in fact favourable to the mother, one would assume.
Yes,
And there's obviously a process of assessment has to be gone through afterwards.
precisely.
And it's for that purpose one should really drop the language and simply deal with the facts.
That's precisely so.
But what do the facts go to? Do the facts, in a case where there is, the court has held that it's more probable than not that the father, say, is the perpetrator,
Well,
but it obviously remains a possibility that it was the mother in very many cases, because that's just the way life is. Once that conclusion has been reached, when we come to look at the factors, what do the factors relate to? Do the factors relate to the risk to the child of the kind of event which occurred, which might, notwithstanding the primary finding, still have been caused by the mother or not?
well, my lord,
Or are they elements of the factors which have to be excluded because of the rule in B? Because some of us might think,
Yes.
perhaps not having been parties to B, that there's something very bizarre about this, because only a lawyer could have invented where we are now. Because if the whole thing's about the risk to the child, then whatever percentage you attribute to the father, there still may very well be a significant percentage which would be attributable to the mother, or potentially so. It might be up to 49%. It could certainly be the 30% that my lord refers to. But as the law stands at the moment, as you advance it,
Yes.
following from B as I understand it,
Yes.
in the case where it is possible to say on the balance of probabilities, the father, then none of those factors are relevant so far as an assessment of the mother is concerned in the context of risk to the child. Is that right or wrong?
may we illustrate that point?
Is it right or wrong first?
I think the short answer is both. But, my lords, if we put ourselves into the position of the judge hearing the fact-finding hearing, he will or she will be in a unique position. He will hear a vast canvas of evidence, potentially, including...
So he'll be able to say 60-40.
Well, he will...
Best person to say 60-40.
He will be able, at the conclusion of the evidence, one hopes, in the vast majority of the cases, to be able to say, I have heard the evidence, I have weighed and analysed that evidence in relation to A and B. I find that A is, on the balance of probabilities, the perpetrator. There will, as we say, be cases, because it is a feature of situations like this that parties are not frank, that the judge will simply be unable to identify a perpetrator at all to the requisite degree. But he is the judge who has heard this possibly days of evidence, and he is the conduit by which that evidence is passed on to those doing the assessment. So it's important that the judge takes the evidence that he hears and sees that it is properly the focus of work during the assessment. And we have given, by way of illustrations, examples in paragraph 25 of our case, just by way of illustrations of the kind of thing that the judge may want to pass on to those undertaking.
This is in the uncertain perpetrator.
This is in the uncertain perpetrator case on.
But if it's
on that
a certain, your definition of a certain perpetrator,
yes,
is one who's been held to be probably the perpetrator.
Yes.
And that's the definition of certain perpetrator. I mean, only a lawyer could have thought of that.
Yeah.
Because,
No, there is no such thing as certain or uncertain. It's only a lawyer who brought those words in.
well, maybe I was simply using the expression used by Lord
but
Nichols.
it's not a term of art. There is nothing in the Act that says that. The use of the word certain doesn't reflect any of the general principles.
Okay. Well, let us not use. Lord Nichols' day appears to be over. But your definition, when Lord Nichols is talking about an uncertain perpetrator, at any rate, whether it's a term of art or not, he is talking about the case where it isn't possible for the fact finder to hold on the balance of probabilities that it was A or B.
Yes.
And in that kind of case, it is, I think, common ground, isn't it, that all the factors, the judge should focus on the factors,
Yes.
the first judge, because he or she will be the best person to give a steer to the second judge, the person who's carrying out the welfare assessment.
Yes.
And all those anything that's a relevant factor, the second judge will take into account, according to the steer given by whatever the findings of fact of the first judge are. That's the way it works. But if it's a case, a different kind of case, where it is possible to say, perhaps on a narrow balance, but nevertheless the balance of probabilities, that the perpetrator was A, then when you come to consider the position of B, say the mother,
Excluded as the perpetrator.
excluded as well, you can put it like that if you wish, but yes. Then, when you're considering the risk factors, do you take account of any of the factors which were relevant at the first stage in relation to the mother and might have led to the conclusion that there was a risk of X, even though I quite see you don't, or are they irrelevant?
There will frequently be issues arising from the identification of the perpetrator, such as the failure to protect issue, which is always an ancillary issue in these cases, or a continuing unwillingness to accept that the father may have been the perpetrator. And the judge will want to
you can take account of all those factors, because they're general factors in the case.
Absolutely.
But what you can't do is take account of the possibility that that B, in this case the mother, might have been responsible for the...
No. Once you have found on the application of the civil standard of proof that F, the father, is the perpetrator, then that is a substratum, the factual substratum in which all those work for the future.
But how does this work in practice? Because in this case, the factors which the judge might have taken into account in coming to her 40% assessment were not very serious in themselves at all.
Well, that's our submission, certainly.
But there are some that somebody might want to take into account. I mean, you mentioned a moment ago the unwillingness to accept that these were non-accidental injuries.
Yes, those are...
And there are other factors which don't point to her as being the perpetrator, but nevertheless may have some bearing on the care process.
Absolutely.
But the basic point I think you're trying to make is really reflected in Lord Hoffman's paragraph 2 in B, in Re B, where he says that the law operates a binary system. The values are either 1 or 0.
Well, it applies as much to the perpetrator as it does to the...
And I mean, if you say 1 for father, it's 0 for mother, and that is a given from which things proceed. But they proceed upon the basis that there still may be factors which are relevant to the consideration of the child's interest in the overall assessment.
Absolutely. Just because the mother has not been found to be the perpetrator doesn't mean there may not be a whole raft of welfare concerns that have to be looked at stage 2. Failure to protect, unwillingness to accept the judgment, difficulty in disengaging from the father because of the nature and dynamic of their relationship. And we give some
dishonesty in relation to the people who are trying to protect the child.
unwillingness to work openly with the
All
professionals.
of those things may be risk factors.
They are all risk factors for the future, and the fact that she has been excluded does not for a moment mean that there is, as it were, an automatic outcome that the children will be returned to her care. By no means. That is the point at which the application of Section 1.1 comes into play, and the assessors work through that. All we are saying here is that it's important that the judge transmits through the judgment to the assessors those concerns that he has seen in play during the days of evidence that he will have heard, so that that opportunity is not lost to communicate them on. At paragraph 25 of our appellant's case, we give some examples of that. The judge may be, for example, concerned about the extensive criminal record for violence of one of the parties, even though that has not been a factor pointing towards the perpetration. There may, even though the mother has been found not to have been the perpetrator, nonetheless be, for example, a long-standing dependency on alcohol or substance misuse of some kind, which will directly impact upon her capacity to care for the child in future, and which the judge may want to focus the assessors on.
But I mean, you say she has been found not to have been the perpetrator. All she is found is probably not to have been the perpetrator.
That's the test.
Well, I mean, that's the issue, as I understand it, before us, is it not? I rather understand that the contrary is argued.
Well, we started by saying, if my Lord recalls, we started by saying, in response to the first issue that we had identified, the consequence of Re B is that the test to be applied to identifying perpetrator in fact-finding hearings is the civil standard of proof. Nothing more, nothing less, not heightened cogency, but that is the test. And when we started, there was some measure of agreement to that. Lord Justice Thorpe possibly notwithstanding, and Her Honour Judge Kushner notwithstanding.
Could I just ask you this about paragraph 2 of Lord Hoffman's speech? Because he applies this binary principle, what he calls a fact in issue. And then he says, if the party who bears the burden of proof fails to discharge it, a value of naught is returned, and the fact is treated as not having happened. Now, how does that apply here? The fact in issue is whether X was the perpetrator. The judge says he can't tell. Now, is that fact then treated as not having happened? So is he then treated as not having been the perpetrator? Or is it, can one still take account of the risk that he was the perpetrator?
Lady Hale answered that question in the judgment, if we may say so, at paragraph 32.
Thank you.
Sounds as if you know my judgment better than I do.
Well, 31 is also very important.
Yes, it is. Yeah, we'll pick it up from paragraph 31. This is from the second sentence. In this country, we do not require documentary proof. We rely heavily on oral evidence, especially from those who were present when the alleged events took place, day after day, up and down the country.
Forgive me, it's the first sentence that's really important because, as I understand it, Lady Hale is criticising the judge for not having made a finding.
Yes.
And how does that fit in with the uncertain perpetrator line?
With the what?
The uncertain perpetrator line.
Yes. It fits in this way. I think we were looking at a very specific first instance judgment in Re B when there was a certain artificiality about the way the evidence had been interpreted in order to identify questions of academic interest, and that in reality, if I may say so respectfully to the first instance judge, that grappling with the issues in the way that judges up and down the country have to do every day, it would have been possible to identify a perpetrator against the backdrop of the evidence in this case. There will, as we say, and I have said on a number of occasions, always be cases where, despite the efforts of the judge to see if it is possible to identify a perpetrator on the evidence, he or she simply will not be able to do that. The evidence won't permit it because of the lack of frankness of the parties or the fact that there may have been injuries over a period of months, and it's impossible to track down and identify who was caring for the...
I follow that, but then what is said in both these judgments, as I see it, is that then you proceed on the basis that the F, if you like, was not the perpetrator. Because
no,
isn't that exactly what Lady Helen is saying in paragraph 32?
No, if you can't identify a perpetrator at all, it is quite the reverse. They still stay in the pool. They still stay in the pool.
It is not essential, as Lord Brown made clear right at the outset, for the purpose of crossing the threshold,
right,
or indeed for the purpose of making an order as a result of that, to establish who did it. That is not essential. Whereas it is essential to decide that things happened that crossed the threshold.
Yes.
Absolutely.
That is essential.
Yeah, yeah.
You may be left in a situation where you cannot decide who did it, but you can decide what factors are going to be relevant for the welfare of this child in the future.
Yes.
It may also be worth recalling, some of us were concerned with a case earlier this term in which the judge had identified a perpetrator at the fact-finding hearing, and then as a result of the welfare inquiries that were subsequently made, changed his mind.
Yes.
Fresh evidence emerged in the course of the welfare inquiries, which caused him to decide that he'd got it wrong. And so he revised his view. Now, that is always a possibility.
And there is the opportunity and the case law that provides for precisely that situation.
I understand that, but it's still not clear to me whether the question whether F was the perpetrator is what Lord Hoffman calls a fact in issue or not.
Well,
I mean, I see that the fact in issue is clear in the Section 31(2) case, because there it is, it has to be decided. There's a preliminary threshold question. I quite take my lady's point that after that, and I wonder whether this next question is a fact in issue, whether the binary principle does apply to this further question.
Yes.
Because I am concerned myself that if it does, we do get this very, very strange, or some of us might think very strange position, where if it's established that F is the perpetrator, then you can no longer take account of the risk that it was the mother who was the perpetrator. Whereas if the threshold is not crossed, so that you can't say that F probably did it, then the risk of either F or M being the perpetrator is relevant at the later stage. And that's the point that's troubling me.
Yes.
Maybe it isn't a real point, but it seems to me quite startling, the distinction.
Well, Lord, one has to go back to the judgment of Lord Justice Wall in the case of Re D that we were looking at earlier this morning, where the judge said that the judge shouldn't strain to identify a perpetrator. The judge isn't obliged to try and identify the perpetrator. The judge has to just carefully work his or her way through the evidence to see if at the end of the case the evidence properly evaluated points to a perpetrator, and the civil standard and the exercise is no more nor less complicated than that. And I take my Lord's point. I take my Lord's point that the binary analogy doesn't fit as comfortably into that exercise as it does when one has the single issue on the threshold criteria. Was there significant harm here or not? Either the judge finds it was, or the judge finds it wasn't. And it's on that basis. But in relation to this probably rather more subtle exercise of identifying the perpetrator, we say that the analysis helpful elucidation of the process that does necessary proof, not requiring documentary proof, relying heavily on oral evidence, especially from those who are present when the alleged events took place, day and day, up and down the country, on issues like judges are making up their minds who to believe. This is the process as to identification of the perpetrator. They are guided by memory to the inherent probabilities, which has ceased to be a factor once we have found that no matter any contemporaneous documentation or records, any circumstantial evidence tending to support one account rather than another, and their overall impression of the character. This is the day-to-day work of the judge applying the civil statute, looking at who did it against the backdrop of a right philosophical dispute.
But I read 31 and 32 just as Lord Hoffman paragraph 2 as actually being squarely directed to the preliminary, the threshold question, yes or no, was there abuse? Which does have to be, and which unless the caring people approve it, I mean, you're not through the gate. On the face of it, it seems to me a little more problematic and less obviously directed to the later issue where there aren't the same questions of burden of proof when you're looking at the child's welfare.
I don't want to, unless it's helpful, to go back to those passages of Lord Hoffman and Lady Hale that we have looked at, where it is perfectly clear, and as we said when we started this appeal this morning, it is perfectly clear that the test that was being identified on the question of who is the perpetrator is the balance of probabilities.
Well, that's
the test.
what Lord Justice Wall said in the passage you refer to us. Indeed, I mean, he says if an individual can be properly identified on the balance of probabilities, then it's the judge's duty to identify it.
The judge's duty to the parties, to the child,
yes,
to the process of
indeed
assessment.
to each of the parties. And then, do I understand you to say this, that having got to that position, having identified which of the two, and one's assuming there are only two,
yes.
he identifies, and that exercise is then complete.
Yes.
The factors that may have been relevant to identifying the one who's omitted at that stage come into play for a different exercise.
Precisely.
It's not for identifying the perpetrator, because that's finished with, but there is still the question of assessment, and some of the factors, perhaps all of them, which were relevant to the balance of probabilities at that interim stage may still be relevant at the assessment stage. I don't find that very difficult myself, but I mean, it may be...
You say you have to shut your mind to the possibility. Besides, of course you have regard to those factors, but you have to shut your mind to the possibility, lingering in your mind, that actually you may be wrong in judging the husband or the father, whatever it is, to be the more probable, the 51%. You have to ignore the fact that you're left with a lingering doubt whether it wasn't mum who actually hit the child or whatever it is after all.
A decision has to be taken if the evidence is there to support it.
And this is a question of different people doing different things, isn't it? Because the judge's job is to take that decision, and then it goes to the professional people who are looking at giving advice for assessments and so on, who have to take as a given what the judge has found on the evidence.
Yes.
Is that the way it works? I mean, that one has to understand
it
the structure
is, as we've looked at.
But the difficulty is, to my mind at least, that, as my Lord Brown says, the Section 31(2) point is a gateway question to which one can readily see that you have to know the answer to that, you have to apply a balance of probabilities test, and there it is. All other questions go to the welfare question. They may conveniently have been treated as part of the first hearing, because that may be practically more convenient, because the judge will have heard all the evidence which may relate to it. But they actually go to the welfare question. And that being the case, I wonder, absent any clear and binding authority on this court, whether we should hold that the Lord Hoffman's analysis applies at the second stage, which is all about risk and welfare of the child. Now, if there's a clear and binding authority, we just have to look at it. But Re B isn't such a case, because that's about the gateway. And I respectfully suggest that my lady in paragraphs 31 and 32 is focusing on the gateway. There's a slight difference between paragraph 3 of Lord Hoffman and paragraph 32 of Lady Hell, but only a slight one. But they're talking about the gateway. And there may be a case which is binding on the court that we must apply the Lord Hoffman test or the House's test to this class of case.
Well, we
But
do.
I just wonder.
Yes, we do have to ask ourselves if this is part of the problem with mental hygiene in children's cases. I mean, it's not easy. It's not easy to do. It's not easy to apply. Because, of course, we're all concerned to do the best for the particular child, and we're all concerned to take everything that we possibly can into account when doing our best for the particular child. But there is an important element in Re-H, which was actually the foundation of the division between the majority and the minority in Re-H, which is how do you decide whether there is a risk of future harm when your basis for deciding that there's a risk of future harm is past facts. And the majority said you have to find those past facts proved to the balance of probabilities, on the balance of probabilities. You cannot simply take the possibility that those past facts happened into account in deciding whether there's a risk based on those past facts. That was, have I summed that up accurately?
So that's at the gateway stage.
Well,
Depends what those facts are.
yes, it does depend what those facts are. And what I'm getting at is that when one's talking about risk, if the majority were right in Re-H, and you are looking at the risk for the future, and the reason you say there's a risk for the future is not all these peripheral things like character, drinking, drugs, lifestyle, or whatever, but is that something happened to this child and that person is responsible for it. Well, then you can't simply take the possibility that that was the case as a rational basis for concluding that there is a risk in the future. That's what the majority decided in Re-H. The minority took the other view. So it's there is that authority which is in point on this.
And there was some attempt, effectively, to revisit that in Re-B2. And the point, as my lady makes, is that if one is trying to evaluate likelihood of future harm, it can only make any kind of logical or forensic sense if it is predicated on past harm actually having been identified and found.
I mean, we do have that for the threshold in this case.
Yes.
Because we mustn't forget that we're dealing with two children.
Yes.
We're dealing with a child who suffered harm, and the question is what's best for the child in the light of the fact that that harm was suffered while in the care of his parents. And we're dealing with another child who has suffered no harm at all.
Yes.
And we are dealing with what is it likely that that child will suffer harm attributable to a lack of proper parental care if looked after by mum.
And we haven't addressed that, but in the context of this case, that poses a very difficult issue indeed, because if we are right, and Judge Kushner did apply a heightened cogency test, and she should not have done, and therefore following that analysis through, the mother was truly exculpated. By the time the judge gets to the end of the forensic process, she finds as a fact that there has not been a failure to protect and that the mother and father have separated, and it is difficult logically to identify a basis for likely future harm in relation to the second child, W.
Well, that was the point I was seeking to flag up for us all to have in mind, if the majority in Re-H were right.
Yes. Bringing this back then to my Lord Clerk's point, what is the judge to do? The child has sustained significant harm of some kind, and the inquiry in focus is who is responsible for inflicting that harm, for causing that harm. that will be the sort of case that judges up and down the land hear day after day. Perhaps it would have been anticipated that there would have been arguments as to whether significant harm had occurred at all, but in the end, it frequently comes down to who was the perpetrator of such harm, the harm having been conceded, as was the case here. And the approach, we say there, is precisely that we were looking at in Re B. The judge simply has to look whether it is more likely than not that something did take place, and then make up his mind on the available evidence who was the likely perpetrator of it. Now, at that point, my lord, we say that any factors which might have pointed to the mother, can never be certain. There isn't a requirement to be certain. There just has to be, where possible, if the evidence supports it, a factual premises on which one could move forward, or else judges would never be able to take decisions on these important issues. And that would clog up the assessment process, because if judges are unable to find as between two or more potential perpetrators, it's always a more difficult case to manage. If a finding is made, if the evidence is receptive to a finding, then at least that is clear for the future. Now, you've already been through that exercise by that stage. You've already decided that such and such a piece of evidence points to the mother and such a piece of evidence points to the father. That process has been gone through. Thereafter, any other manner of risk factors, my lord, really goes to the application of the welfare checklist in the assessment stage. And in our submission, this is not particularly difficult to state. It may be very difficult for the judge in practice, but as a rule to guide the judges, it is not difficult. Threshold criteria either met or not on a binary basis. Either the evidence points to the identification of a perpetrator or it does not, and if it doesn't, one moves forward on that premise. And then, no need to comment on likelihood short of a finding, just highlight those issues that are going to be helpful to those conducting the assessment, because to do otherwise is to confuse the picture hopelessly, we say. And we now have illustrations of how confusing it can be in three authorities.
Are we to get any more out of the case we're looking at, O and N? I think we looked
yes.
at the paragraphs there. Is there anything more apart from 31 and 32
yes,
we should look at?
Yes, I'm sorry, Lord. We were going to go on to look at paragraph 34.
Yes.
33 doesn't really detain us. 34, I wholly understand that parents are apprehensive that if each of them is labelled a possible perpetrator, social workers and others may all too readily rule out the prospect of rehabilitation with either of them, because the child would be at risk with either of them. As already noted, failure to protect is one thing, perpetration is another. A parent fears that once the possibility that he or she was the perpetrator is brought into the scales, cautious social workers will let that factor outweigh all the others. I understand this concern, whether it is well-founded generally or in particular cases is an altogether different matter. Whether well-founded or not, the way ahead cannot be for cases to proceed on an artificial footing, and this is the point. This is where we derive our submission that the judge should, without identifying likely perpetrator below the civil standards, should nonetheless steer the assessment in a particular direction. This, we submit, is extremely helpful advice from Lord Nichols to the judge and to those undertaking the assessments. Rather, in cases of split hearings, judges must be astute to express such views as they can at the preliminary hearing to assist social workers and psychiatrists in making their assessments and in preparing the draft care plan. For their part, social workers, I do not doubt, will have well in mind the need to consider all the circumstances when assessing the risk posed by a carer who is no more than a possible perpetrator, and to this end, transcripts of judgments at the preliminary hearings should always be made readily available when required, so that reliance does not have to be placed on summaries. If I may return to a point my Lord Clark made earlier, although it is said in Lord Nichols's judgment that there will sometimes be a second judge at stage 2, that really is extremely unusual these days, and only, I'm happy to say, only arises when, for example, a judge has been taken ill and it's not possible for a judge to hear part 2. So there is now a unified hearing with one judge continuing to hear both.
I mean, if the judge thinks father is 99% likely to be the perpetrator, should he withhold that from his judgment? Shouldn't he be astute to express that view to assist the social workers at the next stage?
Why does he need to? Either the father is the perpetrator on the balance of probabilities or not, and we return to Lord Justice Thorpe's phrase, better to leave it thus.
What's his phrase?
Better to leave it thus. Either the judge finds the father to be the perpetrator or not. How is it going to assist if it follows on my Lord's analogy that if he thinks it's 99% likely that the father is the perpetrator, he will have so found on the balance of probabilities?
Of course. But shouldn't he indicate that it's not just on the balance of probabilities, he's all but certain of it? All but sure of it. A word I think I can properly use in this context. But I mean, equally, if he's, if it's very much, if you're deciding a civil case,
yes,
I think I remember, it's a very long time ago, one used to say in those cases where, a road traffic accident, and you say, well, it's, I haven't found it at all easy, but there it is on the balance of probabilities. I think it's more likely that it was driver A than driver B. You would say that. Actually, you would say that just to comfort the parties.
Yes,
so forth.
One occasionally heard judges saying, perhaps not so much these days, that I find this case on the balance of probabilities, but if I had had to find it on the criminal standard, I would have been able to find that too. That was quite often a reassuring...
You say you certainly wouldn't have been able to find it on the criminal standard.
Yes, but if what the judge has to do is to decide, as we submit is now the law, on the balance of probabilities who the perpetrator is, it is up to the judge whether he wants to go and say, whether he wants to say more than that. Nothing is to prevent him. The important thing is that having found on the balance of probabilities, the finding is there. It's mere icing on the cake to say, not only have I found on the balance of probabilities, but I found 99% of the evidence that the father is the perpetrator. It may be reassuring to those working with the family in the future, but it is unnecessary once one has passed that standard, one has passed the test of the balance of probabilities.
Well, I have your answer. Thank you.
Well, shall we move on a little bit and just see where we're going to next? I was asking whether we've exhausted O and N. We've seen 34 and 35, and that's helpful. Yeah, thank you.
You're endorsing 35, all this help to be passed on to the social workers, is that right?
Yes, the information when the in response to Claire's comment before lunchtime, our case, this is not an uncertain case, but we are addressing the issue raised, what is the court to do in those uncertain cases, and what information is to be fed back on to...
And do these social workers look at all the process by which the judge has eventually, after tortuous reasoning, come to think that actually on the balance of probabilities, because of one particular piece of evidence, he's going to go for that. And they look at that and they say, oh, well, gosh, if it hadn't been for that piece of evidence, look at all these other factors that are there. Do the social workers look at that, or do they just look at the conclusion which he's reached?
They will follow the transcript of the judge, the full transcript of the judgment will be made available immediately following the fact finding for all the professionals involved, but particularly for the parents to sit down and work through the findings of the judge with their advocates and see, as we looked at this morning, whether it is possible for the parents to accept the findings of the judge.
I understand that's an idea well, but I mean, just what do they do when the social workers look at this and say, look at all these things? I mean, this judge, well, it was touch and go.
Well, once the judge has found it, there it is. That's the factual substratum of the case.
So they don't read, they pay no attention to what he said.
Well, I'm sure they will be interested to know how the judge came by his conclusions, because that will inform their work with the parents.
But, I mean, I can see, of course, if there are things like drinking and all that sort of stuff, then that is easy. You take those into account. You would, even if there was no question of an assault or something like that. But you take that into account. But the questions I find more difficult is, if it's suppose it is a competition just on credibility of evidence which has been given.
These cases will not be determined on pure credibility. They will be decided against the backdrop of a broad canvas of evidence, which will include very often expert medical evidence, and which will enable the judge to evaluate time windows when injuries have been sustained and see who was looking after, who was caring for the child in that window. So it will be supported by a broad range of evidence, not merely credibility, because we agree that if it's just a question of credibility, if there is no solid foothold to the evidence and the judge doesn't believe either of the parents, it's always going to be difficult for the judge.
But he may just decide in the end, he preferred one particular sister or whoever it happens to be who came in and said, well, that actually was what happened. Now, he accepted that. But but all the other bits of the evidence, for reasons which he sets out to maybe considerable length, left him in very considerable doubt about what the position was. But then he turned on one particular thing. Now, do the social workers pay any attention to all these factors or not?
The social workers will look at the whole string. I'm sorry if I'm repeating myself, my Lord, I'm trying to be helpful. The whole string of welfare risk factors, which will have been, some of which will have been highlighted during the course of the hearing, some of which will come to light during the process of the social work assessment itself. And they will evaluate future risks for the child, the care plan, where the best interests of the child are likely to lie, on the conglomeration of that information. But if the judge has found that X was a perpetrator, that's what they must accept, and that's the purpose of it, so that they all go forth from the same factual premise.
My impression was, and maybe Miss Grocott and Miss Judd will, as they are actually instructed by social workers, so to speak, be able to help us with this, but my impression was that social workers did have the whole judgment. Yes. And they would go through it with their clients, saying, well, what do you say about this? What do you say about that? The judge found this, the judge found that. And what do you say about it?
I hope I'd not
that was my impression.
I hope I'd not given any other impression. That is precisely why the transcript is ordered. The social worker will sit down and at stage 2 of the case, the judge's findings and, in response to my Lord Rogers, the analysis behind those findings, the thinking that has led to them, will be gone through with the parents, line by line. It will be the cornerstone of the comprehensive...
doesn't like the answer that he or she gets when mother tries to explain away this bit. of the evidence, and the father having been there. Mr. Washington doesn't like that.
Yes.
Then what?
I'm sure that often arises where social
So
workers...
what happens in that situation?
They are bound by the judge, by the judge's
so
findings.
slightly-
The judge has come to
Well,
his
somebody
conclusion.
has to take a decision sometime. and
Somebody
that's-
else...
that's the
I know, but
problem.
it's all this help that's being afforded to them, apparently, to talk about things which then they can't actually do anything about.
No, that's the purpose of the process. There will be many cases, I'm sure, where more cases where parents do not like the findings of the judge either. But there will be those cases where the social workers perhaps had anticipated a different conclusion. But that's the beauty of it, so that problem doesn't go on and on and on, and there is a proper substratum for future assessments. And as has been said, these things are not cast in stone forevermore. If it comes to light during the course of the assessment that there has been a miscalculation as to where the evidence should fall, it can always be revisited, and from time to time that does have to happen. But what we say is, as Lord Justice Wall said, there simply has to be a clear factual premise where it is possible to move the process forward. And judges have to make these difficult decisions in the passage that we're looking at from Lady Hale, up and down the land on the whole raft of evidence, contemporaneous, oral evidence, expert evidence, the whole raft of it, and come to a conclusion. It's a difficult task, and identifying the perpetrator in a case such as this is always going to be, as is repeatedly said in the authorities, among the most difficult tasks that judges face. But that is what the judge is there to do, and has to do.
Yes. Well,
yes.
Time is moving on a little bit. I think we're quite anxious to hear from other counsel. I think looking at your timetable, you've got about 3/4 of an hour or so to go.
Yes.
And we don't hold you to it precisely, but it does help us to have an idea of how the argument should be
My Lords,
structured.
I think I can comfortably finish within that time. I hope a little shorter than that. May we just go to the three cases that I referred to before lunch, because these illustrate the difficulties of talking about these concepts of likelihood and probability or possibility if you cannot find the case established in respect of the perpetrator on the civil standard. We see it first of all in the case of A, which is at tab 4, paragraph 16. This was the case where a very, very young child had suffered head injuries and an ankle injury when living at home, and also very serious injuries whilst at hospital. And at the fact-finding hearing, the judge found that the mother had propensity to mishandle a child in a particular violent way, but on the balance of probabilities, whilst the mother had caused the injuries to the child during her stay in hospital and one of the major injuries at home, the judge was unable to exonerate the father from the one remaining injury to the ankle, and it was contended on his behalf on appeal that given that the judge had found the other injuries to have been caused by the mother, it was improbable in a very high degree that two parents would have been inflicting injury on the child. And Lord Justice Thorpe dealt with that situation in this way at paragraph 16. I am in no doubt at all that the points made by counsel do lead to the conclusion that the mother was the more likely perpetrator of the ankle injury, even if the father remained in the frame as possible perpetrator. I would surmise with considerable confidence, the judge said, that had the judge been asked to amplify that paragraph in her judgment by recording that although she could not exonerate either on the evidence and in the light of the earlier findings, the mother was clearly the more probable of the two, she would have done so. Mr. Bennett has indicated that it would be helpful to his client authority were this court to indicate that the construction of equal likelihood is not one that can be validly adopted. I say that without hesitation. I do not think the judge meant that these two were equally likely. Certainly she did not say it, and from what I know of the case, and accepting that I have not heard the evidence, it is manifest that of the two, the mother is the more likely to have perpetrated the injury. So in relation to this injury to the ankle, not finding it on the balance of probabilities to be the mother, the judge nonetheless went on to find that the mother was, as he put it, the more likely of the two to have perpetrated the ankle injury. I'm very conscious that Miss Grocott doesn't rely on that case and says that it cannot be supported.
Sorry, you're conscious of what?
I'm very conscious that Miss Grocott does not rely on that case and says it cannot be supported. My Lord, may we just pause there with it and look at almost identical circumstances arising in re M.
Just before you do that, in paragraph 16, the expression the more likely perpetrator.
Yes.
Does that mean, is that a balance of probabilities test?
It can't be. It cannot be, because the judge has been unable to decide who caused the injury.
So what does it mean?
I do find it very, very difficult. There will be cases, I'm sure there will be cases, where you could intellectually say that X is more likely than Y, but nevertheless I cannot find that X did it. This is the distinction that Lord Kerr was making earlier. I can think that that might be the case. But it's much more likely, one would have thought, that if you've got all this evidence pointing towards Y being the perpetrator, one would be able to find on the balance of probabilities that Y was the perpetrator. And the puzzle is, why not?
Well, that is what we say. It's not necessary to overcomplicate it in this way. One simply applies the civil standard to the question of perpetrator, and either the evidence is there to support a finding or is not. It does not need to be more complicated than that. That is the basis upon which we can work and move forward. And to be introducing, let's look at that scenario that we've just looked at with Lord Justice Thorpe there. If he finds that he has not established, if the judge finds that he's not established on the balance of probabilities that the mother is the perpetrator of the ankle injury, but is the more likely perpetrator, then what are the assessors supposed to make of that? Where is the factual substratum? How does it help them? What kind of finding is it? It's not rooted in evidence. It's just an anxiety of the judge, ultimately. And it's perfectly legitimate, therefore, for other professionals working with the parents to have anxieties of their own. The question is, will they? Because an anxiety from the judge, expressed in those terms, will be interpreted, we anticipate, as if it were a finding made by a judge. It uses almost identical language. And that is not what the judge is intending to communicate. And it runs the real risk of miscarriage of justice if the assessors are working on the basis that they perceive the judge to have made a finding which he has not done. That is the danger of it.
Fundamental underpinning of all of this is the best interest of the child. Is it not an argument that the anxiety of the judge should play into that evaluation?
If the judge is anxious, if he's not satisfied that the evidence identifies a perpetrator, he should not be making the finding.
So he shouldn't express any anxieties, even though theoretically those anxieties might prove to be well-founded.
That's not, if I may say, not quite what I'm saying. The judge may have a whole raft of anxieties which are well-founded, genuine and supported in the evidence, but don't go to the issue of who the perpetrator was. If the judge finds that X is the perpetrator, those anxieties don't evaporate. They remain there. They're analysed, going through painstakingly through the judgment, being picked up during the course of comprehensive structured assessments designed to put a plan together that will promote the long-term welfare interests of the child. But on the evidential discipline And this is what, if we may respectfully say so, judges are there to do, to apply their forensic discipline to the facts of the case and establish, does this case identify a perpetrator or not? If it doesn't, these are my anxieties about the future. But I don't want to in any way undermine the integrity of the future assessment by speculating as to who may have done it. I will ventilate, by all means, my anxieties about it, but that's a different forensic exercise altogether.
Even if the anxieties are that the person is the perpetrator.
Well, this is the difficulty, my lord. If the judge hasn't found that X is the perpetrator, what is the status of an anxiety reflected in the judgment that X may be the perpetrator? The danger, we say, is that that is interpreted thereafter by those working with the couple as if the judge had found that X was the perpetrator, and that really does compromise the integrity of the assessment process.
Does it come down to that because of the dangers of misinterpretation? The anxieties should not be expressed.
On this, we agree entirely with Lord Justice Thorpe when he says, on this point, if you can't establish it on the basis of the balance of probabilities, better to leave it thus. I think the phrase is safer to leave it there.
That's slightly overstated, because it isn't really leaving it there entirely, is it? I mean, the cases that cause concern are ones where there's no direct evidence. Nobody saw the injury being inflicted, and therefore an inference has to be drawn from various factors. And of course, the closer they are to the eyewitness situation, the more likely it is that the judge will be able to find on balance of probabilities who did it. But the cases that are very difficult are where they're quite diffuse, factors that can point either way. And you're saying, I think, that the judge's task, his judicial task, is to face up to that and assess these factors and reach a conclusion on them on the issue of perpetration.
Yes.
That these are factors which can bear also on the future. They may be indicating irresponsible behavior of various kinds, which he concludes don't actually prove on a balance of probabilities that this individual is the perpetrator, but nevertheless give rise to anxiety and should therefore be mentioned so that in the assessment for the future they can be taken into account.
My Lord articulates our case, no doubt, far better than I have been able to do, but that is indeed precisely what we say. Taking on board what Lord Justice Wall says, the judge shouldn't strain to make a finding. There isn't an obligation to try and make a finding. If the evidence is there, it is there. If it's not there. And there will be cases where it's much easier, either because of the proximity of the events to eyewitness observations or because medical evidence. There might have been, for example, an encephalopathic collapse of a child when he was in the sole care of a particular individual. And the medical evidence may say that because of that, whoever had care of the child at the time of the collapse must have been the perpetrator. Those cases will, in fact, be very much easier. It's those in the middle that are always going to be difficult. But it doesn't help, we say, I won't repeat it again, it doesn't help, we say, to be speculating on degrees of likelihood when the evidence simply doesn't support.
One view of this case, I'm so sorry.
So I was just going to say, sorry, it's just to say that I think you also mentioned you used the phrase evidential discipline, and I think you're saying that actually the judge can't shrink from the task by sliding behind looser words, looser expressions like possibility and anxiety, and, as it were, rather evading the issue, which ultimately she or he has to decide if there's evidence there to enable the decision to be taken.
Well, that was the passage I was looking to before of Lady Hale, when she said in Re B, that is the judge's task, however difficult, that is, as Lady Hale put it, that is what judges are paid to do.
Well, it looks to me as if the fairly clear wording of section 31(2) would have been reasonably easy for judges to apply, but for the fact that it's spawned no less than 4 decisions already in the House of Lords.
Yes. The establishment of the significant harm is, in many cases, not so difficult. It is this question of perpetrator that is difficult. And we've seen how Lord Justice Thorpe looked at it in Re A. May we just have a look at how...
Can I just put this to you in relation to the case we've just looked at in Re A? One way of looking at Re A, if you just read what Lord Justice Thorpe said, what is that the appeal was dismissed because the father wanted a finding that he'd been exonerated.
Yes.
The judge, an extremely experienced judge, I think, in this area, said that she was left with, in relation to the ankle injury, she was left with 2 possible perpetrators, neither of which she could exonerate. That's quoted at paragraph 9. Then we get to paragraph 16.
Yes.
On the question of whether it was more likely than not that it was the mother what done it.
Yes.
The Court of Appeal said yes, that's correct.
Yes.
It was more likely than not, but nevertheless, the judge's conclusion that it wasn't possible to exonerate
The father.
Was left in play.
Yes.
So the logic of this case is that you have a case where X has been held on the balance of probabilities to be the perpetrator, but it remains relevant that the other person might have done it.
Yes.
Because that's the underlying logic of this case, which was the very point we were discussing earlier.
That's the point.
And here we have the decision, and what's wrong with that?
Well, we say that's wrong because it's using a second tier of likelihood. Can we look at the next case?
Well, it may be, but that depends. Well, then we're back to Lord Hoffman and what's meant by primary facts and all that. But if it's just a question of the assessment, then what's wrong with it? Anyway, it's a decision, and isn't it? And that is what the ratio of it is.
It is a decision. It is a decision. May we have a look at another one, which puts it in?
But I'm right in saying that's the ratio of it, aren't I?
Certainly. Yeah, and as I said, in fact, it's so difficult to sustain that, as we understand it, Miss Grocott doesn't rely on it, but she may be revising her position.
We'll come to that.
May we just have a look at the Re-M case, which is at tab 2. This is not a dissimilar scenario, my lord. There are 2 sets of injury. The judge found that the mother had caused the first set, and although he could not exonerate the father from the second set, he found... this is Judge Plumstead. She found that it was most likely to have been the mother responsible for both sets of injuries. So the same scenario, keeping the father in the frame and nonetheless finding that the mother was the most likely perpetrator. And Lord Justice Ward deals with that at paragraph 31 in a very different way to Lord Justice Thorpe. He says that, in my judgment, the inescapable logic of this approach renders it impossible for a judge to find as a fact, this is looking at Re B and Baroness Hale's speech, paragraph 30, impossible for a judge to find as a fact in a case where it is plain that either X or Y inflicted a particular injury or injuries to a child, that X is the perpetrator, but that Y cannot be excluded as a perpetrator. If the judge finds as a fact that X is the perpetrator, then X alone is the perpetrator, the reasoning of which we entirely adopt, as my lord will anticipate. Such a decision has to be reached on the balance of probabilities. This is the application of the test that we contend is the right test, and the right application of it. It was thus not open to the judge, in my judgment, to say that she found the mother was the most likely perpetrator, and then go on to include the father as a possible perpetrator. Identification of the perpetrator is often the most difficult task faced by a judge. Sometimes a child is injured whilst in the care of both parents, and the judge is unable to decide which of the two is responsible. Sometimes one parent is held to be responsible and the other is held to have failed to protect the child. In the instant case, it seems to me that the highlighted passage in this particular paragraph of the judge's judgment is capable of several different meanings, and the matter was remitted back to Judge Plumstead to consider. But we, with respect, entirely adopt that analysis. It is simply unworkable to find that X is the perpetrator on balance, but then Y cannot be excluded as the perpetrator. And it came into focus.
Why is it unworkable? It may be wrong in law, but why is it unworkable?
Well, it's how does one assess on that basis? X did it, but Y can't be discounted as doing it.
In the same way as presumably you do if you can't tell.
If you can't,
then you've still got to take account of all these various factors, including the likelihood, as my lord says.
Maybe reverse the hypothesis. If that is the situation, why make a finding at all? And we see that where it is possible to make findings, it is in the child's interest as much as anybody else
I mean, I could conceive myself a judge coming to a view that A rather than B did it. But then if the judge asked himself, would you actually entrust your own child to B? I think that the judge might say, well, actually, no, because although I came down in favour of A being the perpetrator, I did have really quite a lot of worries about B, and I just wouldn't, if I were looking after my own child, I wouldn't give that child to B.
My lord articulates the responsibility and the real dilemma facing the family judge in every case, every day. If he gets it wrong, the consequences are serious. But that doesn't mean that decisions must not be taken. They must be, however painful, however difficult, and to the standard that has been prescribed. There is never going to be certainty. And if there were to be that degree of certainty, no children would ever be rehabilitated, because there would always be that element of risk. How is one ever, as a judge, going to discount completely X or Y as a perpetrator, if that is the test? That's why the test is who on the balance of probabilities is the perpetrator. Lord Justice Wilson, finally, my lords.
This is tea.
Tea.
Which we're going to do before lunch. But we'll
do it.
It's been a very helpful background setting to it. Thank you very much indeed.
Which is this one?
This is at paragraph 15. This is a very recent judgment of the 20th of November. And very conveniently, at paragraph 59, Lord Justice Wilson summarises the findings of the first instance judge and agrees for the reasons given by the President of the Family Divisions in the previous paragraphs.
Sorry, which paragraph are we on?
59, my lord.
Yeah.
Was entitled on the evidence before him to reach, in effect, the following conclusions. A, all the injuries on T were non-accidental. B, it was not possible for any person other than one or other or both of the parents to have inflicted any of them. C, it was not established on the balance of probabilities that any of the injuries were perpetrated by the father. D, accordingly being the opposite side of the same coin, it was not open to the judge to exclude the mother from being a possible perpetrator. And E, the mother therefore had to be placed along with the father in a pool of possible perpetrators. So a crisp summary of the facts. And then, as Lord Justice Wilson puts it, the legal interest of the case, this is very much on point, we submit, to the issues that fall into play in this court. The legal interest of the case lies in the fact that the judge, in effect, added a further conclusion. He did so in 66 of his judgments, set out by the President at 29. The judge's further conclusion, which one could call F, was that for 3 specified reasons, the father was more likely than the mother to have perpetrated the injuries. And then Lord Justice Wilson says this: I confess that at first I was surprised by an approach to the effect that in circumstances in which the identity of the perpetrator of the injuries was not established on the balance of probabilities, with the result that two persons had instead to be consigned to a pool of possible perpetrators, it remained possible to identify one of the persons in the pool as more likely and the other as being correspondingly less likely to have been the perpetrator. We submit that Lord Justice Wilson was entirely right to have been surprised by that, because that illustrates precisely the difficulties that we seek to draw to this Court's attention to. The judge said, I had not come across such an approach before. A very experienced judge, both at first instance and in the Court of Appeal, and had not actually encountered this situation before. I realised, he says, that it was logically defensible, and then he goes on to say how that logic follows through. For likelihood in this sphere of law, he says, is something less than probability. And to say, quote, it is more likely that he did it than that she did it, is not necessarily to say it established on the balance of probabilities that he did it.
Well, I don't know. If there are only two candidates, then you've lost me.
Well, I was going to submit that that distinction cannot be sustained. It's a brave, if I may say so, with respect and diffidence to Lord Justice Wilson, it's a brave try, but he then goes on this we do think he's right. Nevertheless, I wondered whether His Honour Judge O'Dwyer had been trying to dance on the head of a pin. We'd use the phrase through a glass darkly during the course of our written submission to try and express the same point. It's just impractical, and we'd say illogical, to have a balance of probability than a concept of likelihood below it. My Lords, I don't think we need to dwell further on the judgment, because that perhaps brings what we've said during the course of our submissions into particularly tight focus.
What did the President say about that? Did he say anything?
No, he didn't. In fact, the President has largely worked through the individual features of the case, but hasn't addressed this particular point. I don't think that's well. He quotes. Yes, he quotes those passages from Lord Nichols's judgment that we went through shortly after lunch, and concludes that, well, as he puts it finally in paragraph 57, in the cases of the father, a level or degree of violence was established in relation to the lesser of the injuries, and that, together with the other matters identified the judge, were plainly risk factors to be taken into account by those involved in the way of her disposal. In the case of the mother, while there were no specific pointers on which to rely on the judge's assessment, there was an overall real possibility that the mother had used violence towards T in the circumstances. So it's a tight analysis of the evidence without confronting, we submit, in the stark terms that Lord Wilson very honestly does, Lord Justice Wilson, at paragraph 72. We don't, with respect to Lord Wilson, as we say, we do not consider that it can be said that there is a logical distinction to be drawn between the concept of something less than probability and more likely than not. That tortures language to such a degree in our submission, as Lord Brown says, that it just becomes incomprehensible. May I, therefore, in conclusion, just tie together the way that we say it is possible to unify some of these conflicting authorities. As we say, Lords, the standard of proof for the threshold criteria, that is the balance of probabilities. the standard of proof for identifying the perpetrator. That is the balance of probabilities. The evidence will either or will not identify a perpetrator. If it doesn't identify a perpetrator, it is unhelpful and misleading to seek to do one, to seek to identify one on a lower standard of proof than the balance of probabilities. But the judge can and should assist the assessment process by doing all he can to communicate those pieces of the evidence which have caused him anxiety onto the assessment process. And we see Judge Plumstead, in the case of Re A, doing precisely that in the extracts that we have set out of paragraphs 26 through to 28 of our written argument that I perhaps do not need to take my Lords to. My Lords, at length, those are our submissions. That is the appellant's case, unless I can assist further.
Could I ask you just to look at your case?
Yes.
At page 16 and 17. It's just to understand what you're asking us to do.
Yes.
I think clearly you're asking us, first of all, to substitute a finding that the father was the perpetrator. That's the thrust of the argument.
Yes.
You then are asking for a discharge of the care order and a placement to be done really immediately as a result of that.
Yes.
And can you explain step C? I'm not quite sure that I've grasped fully what's going on.
Yes, we've said, and this was analysing the point that Lady Hale raised a little while ago about establishing the threshold criteria in relation to W, in relation to W, if the mother is not found to be the perpetrator of injuries to J, if she has separated from the perpetrator, and if, as the judge has found, there is no failure to protect in this case. Yeah. So establishing likelihood in relation to W in those circumstances would be difficult, and we argued there that the appropriate vehicle by which to get that back to the county court judge, and my Lords will have seen that we suggest that is Judge Kushner, if my Lords are minded to do that, should be the section 20 route. But to save time, my Lord, we would, if that situation arose, concede an interim care order to enable that as a vehicle.
So, I mean, you would accept that as a sensible step to take?
As a pragmatic step, we would accept interim care orders in relation to both children, with the matter to be reconsidered at the welfare stage with a substituted finding by this court.
Yeah. Thank
Well,
you.
you've obviously got a basis for an interim care order in relation to J.
Yes, that's always been conceded.
That's always conceded. It's a bit trickier if you're right.
It is trickier, but pragmatically, and bearing in mind that the interim test under Section 38 is lower than the 31.2 test, my lady, we could concede that as a pragmatic resolution to get the matter before the county court judge.
Thank you. Thank you very much indeed.
Thank you.
Ms. Case, do you wish to add anything? Thank you. Well, Ms. Scrocott, I think we're ready for you. Thank you.
Can I return to Re T to finish the question posed by Lord Clark as to the President's position in that case? Paragraph 51 began with the analysis, in particular in the case of Re D, which was given the title in paragraph 51 as NH, County Council and others. That, of course, is the start of the local authorities case. But it's paragraphs 54 and 55 that leaves the question whether the evidence justified the judge's refusal to acquit the mother of any participation in the numerous and varied acts of violence to which T was subjected. That's more problematic, particularly given the statement of the judge at paragraph 66 of his judgment, which had been cited in full at paragraph 29, that by reason of various matters, the father was more likely than the mother to have committed the more serious acts of violence. Mr. Richardson submitted that if that was the judge's view, it justified, indeed it required him to find that the father was the sole perpetrator, the burden of proof simply being the balance of probabilities, i.e. more likely than not. I follow the apparent logic of that submission, which is the point in this appeal, but I am not persuaded by it. In my view, at that point in his judgment, the judge was not focusing upon the task of deciding whether, on the balance of probabilities, he was satisfied that each of the injuries relied on had been caused by one or other parent, as to which he had concluded that two only were attributable to the father. Rather, in respect of those injuries where he felt unable to draw that conclusion, he was making observations designed to assist the local authority, the judge, and others subsequently involved at the welfare stage in the assessment of further risk. That was, of course, counselled and encouraged by Lord Nichols of Birkenhead in Re O&N, Re B. And thereafter he cites all the paragraphs cited in the local authority case.
Yeah.
And at paragraph 57, it seems to me that the judge's observations fall to be viewed in the light of those remarks. At that point in his judgment, the judge was proceeding upon the basis of his stated conclusion that the injuries were inflicted by the mother or the father or both, and that he was unable to be satisfied to the requisite standard of proof that more serious injuries could be attributed to the father alone. Having stated that position of uncertainty, in which he, rightly in my view, felt unable to make a finding on a standard of proof to be separately applied to each parent, he nonetheless sought to indicate in an appropriate fashion those matters in respect of each of the parties which felt to be taken into account in any risk assessment at the welfare stage. The rest of the paragraph, perhaps, is not as relevant.
Yeah.
Can I, before beginning with what will probably be in defence of Lord Nichols, in light of the points that have been taken by the appellant, simply deal with some of the discrete issues that appear to have arisen, especially given the time that we have left this afternoon. One point that is being made, of course, is what impact does the judge's finding have on the assessment team? Unfortunately, in this case, the fact-finding hearing was delayed and delayed again. It did not, in fact, take place until after a psychological report on the mother had been filed by VH. It was filed on the 20th of November, as the, I think, second fact-finding hearing should have taken place earlier on in November.
That's 2007.
2007, yes. It was a particularly benign report. It, of course, said what we don't know is whether the mother is or is not the perpetrator, but it didn't have within it any particular concerns. If you turn to Appendix Part 2, page 479, this is an addendum prepared by the psychologist, dated the 12th of May 2008. It predates the adjunct, but it is made having taken into consideration the findings made by Her Honour Judge Kushner.
Yes.
Given that in her earlier psychological assessment, she highlighted, as I've already said, a benign outcome for mother, or reasonably benign, and stressed that the mother had said she'd now separated from father, and she believed that the mother was going to be able to maintain that, though of course only time would tell. And that in particular, she reserved the issue of, but of course if mother is a perpetrator, that affects the risk. When she received the judgment, this is how the psychologist adopted those findings in terms of the importance to her original findings. The deceit of the mother, in particular, in maintaining a relationship with the father, that she hadn't been honest with any of the assessment team, nor indeed honest in her evidence before Judge Kushner. And on page 480, 1, 2, 3, fourth line down, I am now of the view that the relationship had not ended and that either the mother was trying to extricate herself from it but struggling to disengage because of her own feelings for the father, or that the intention was to only appear as if they had separated. Either way, I'm concerned by mother's lack of honesty and her minimisation of the level of contact that was taking place. I'm also concerned about her capacity to prioritise Jay's needs above her own. And on the next paragraph, the concluding 4 lines talks about the problem she had in terms of prioritising her needs and how they affected adult relationships. The possibility that she therefore actively continued to seek out a relationship with him suggests that she is more vulnerable to forming and maintaining negative relationships than I had originally surmised, although such behaviour would be consistent with her early and rather adverse history. Next paragraph. Mother has misled professionals regarding the status of a relationship. In such cases as this, where there has been a significant injury to a very young infant, it is imperative, in terms of managing risk, that the mother is honest and open with professionals. Her failure to do this leads me to conclude that if Jay were returned to her care, I would not be confident that he could be appropriately monitored and his safety ensured. I would therefore not support a return to his mother's care. And finally, I note that in the judgment it is recorded that neither parent can be ruled out as the perpetrator of Jay's injuries. Then she refers back to her original report. So, my Lord, you'll see how the impact of Her Honour Judge Kushner's decision and those other findings that may have seemed to be quite benign were to the professional assessors of serious concern, and that before one even gets to the issue about whether the mother was or was not a perpetrator, there was already an assessment of a risk of harm to Jay because of the mother's position and the findings the judge made.
That's analysing this and what the conclusion is that's reached before you reach the word finally. Am I understanding that correctly?
It is. Well, the questions were being raised about what impact the judgment had. And the question as to what extent what the judge has to say about either mother or father or any other issue is fed into the welfare stage.
I may have missed something, but what is, when she says that I wouldn't be confident he could be appropriately monitored and his safety ensured, I don't see very much in the previous page or two that relates to safety.
Well, my lord, it's not safety from direct physical harm from the mother that the psychologist is talking about. It's the harm by the mother not being honest and open, not, if it wasn't me, it must be father, not adopting that position, to having a secret relationship with him, and all those factors show that the mother prioritised the father rather than Jay.
But on its own, I mean, that would make her an inadequate mother, not somebody whose children should be taken from her.
Well, the last 3 lines of the second last paragraph about vulnerable to forming negative relationships, that suggests that one therefore is bringing somebody else into the relationship, doesn't it? I mean, and it's a concern that that might itself create risk. Is that a fair interpretation of that?
It is an interpretation. What I will go on to say is that all the assessments that thereafter took place, independent social work assessment, psychiatric assessment, and indeed further psychological assessments and opinion evidence, were predicated on the basis that why have you, if you say you did not injure J, and that you now say, or it was the father, you have adopted this position, and this position. And the overall impact of that is that this mother minimised the injuries in the first place, didn't see them as any real consequence, that she thereafter was unable to bring herself to say, well, I didn't do it, therefore it must be him. And the sum total of that information is that her early childhood years, an adverse upbringing in what was a dysfunctional family with all manner of issues such as the adult relationships being too close and interfamilial, the attitude of the family to injuries to children, all of those features would have made this young mother far more susceptible. And those were the types of issues that were actually considered. I say that because, of course, part of the appellant's case is going to be that if the appellant's case succeeds and you're invited to make a sole perpetration finding substituted for the judge's finding, then that's it. And that the fact that the judge, for whatever reason, will take you to the adjunct in probably tomorrow morning, for whatever reason, that and that alone means that the assessors ought not to have been aware that it was a simple finding of perpetration. The reality is that the finding of perpetration in this case, or the absence of a finding of perpetration, as the local authorities' case is, actually had no real effect on the assessment processes, that the concerns about this mother went forward and were predicated more on the adjunct analysis than on the balance of probabilities. I cannot determine which is the perpetrator.
Could you help, though, about the passage that appears in italics at the top of page 481? This is a quotation from the original report, isn't it?
It is.
And remind me again of the timing of that. That was received...
20th of November.
Right, so it was after the 20th November 2007, yes.
Yes.
So it's a relatively early stage before the fact-finding hearing.
It was indeed.
And so the judge would have read this.
Yes,
and
the judge
it does indicate that the importance of trying to get to the bottom of the question who the perpetrator was.
Yes, the judge would have been aware that there appears on the initial assessment of the mother to have been few adverse factors in terms of the mother's psychological makeup. Those were, however, considerably undermined by the other findings the judge made during the fact-finding hearing, more particularly the failure to accept non-accidental injury, failure to accuse from the witness box the father, when her stated case was it wasn't me, and the deceit in terms of having both physical contact with the father, which was a finding of the judge, and telephone and text traffic. And all those factors caused the psychologist to revise her opinion considerably of the mother and the risk that the mother would pose.
Is it? I have tried to read most of the documentary evidence that we've been presented with. And my impression is that whatever the judge may have said, the local authority has throughout approached this case on the basis that it is very much more likely than not that the perpetrator of these injuries was the father. And the focus of the psychological report and the addendum is on the ability of the mother to protect not only from this father, but from other similar men to whom she might be attracted in the future. And I noticed that that's the same focus as in the independent social workers report,
It is, my lady,
Mr.
yes.
Beckwith's report. If we look at page 532, it's almost exactly the same, isn't it?
It is, my lady, although
These are the concerns about her ability to parent two young children and to protect them from further harm. It's based on her own dysfunctional childhood, her susceptibility to form relationships which could impact on the safety and welfare of her children, because of her passive nature of her personality, the degree of uncertainty of her relationship with the father, lack of a strong family support network, her own abuse as a child, and then the psychologist's concerns. So it's all focusing on factors other than her actual perpetration of these injuries, isn't it?
it is. In fact, it's unclear because we don't have the letter of instruction to Mr. Beckwith. But it is right, as I said, that all the assessments proceeded, in effect, on whether it's a steer or a finding, 60-40, or possibly even less in terms of the way the mother was assessed and analysed.
And the local authority was approaching it in that way, because otherwise it wouldn't have placed all this emphasis on her separating from Mr. Stevenson. Because if the local authority had really thought they were likely to be able to establish that she was the perpetrator, that's not what they would have been doing. They've been doing something completely different.
Yes, my lady. But it brings into sharp relief the issues of the welfare stage and, to a certain extent, how the emphasis on finding perpetrator, certainly in this case, is not how the welfare interests of J&W have been considered in terms of the mother.
So it makes the point very powerfully that if one does reach the position, going back to Lord Hoffman's binary system, that the figure that goes against the mother is 0, that doesn't eliminate the reasons for anxiety that come out of the judge's analysis of the facts in other respects.
Not at all. In fact, it was during that fact-finding hearing that all those other factors which hadn't been uncovered, they had been suspected, and the concern was the mother wouldn't be able to separate, wouldn't be able to do this, that and the other, but they became a reality in terms of the other evidence that the judge heard at the fact-finding hearing.
When did the mobile phone records suddenly come out as they do in so many trials these days?
Well, my lady, the fact-finding hearing began in January and was adjourned until March, and that's why the judgment is April, precisely for the records to be obtained. I understand that special court orders had to be made because of the difficulty of the telephone provider in providing that information, which led to yet another delay in this case for only Jay then, but that ultimately when that information was received, it was extensive, personal, and was really the challenge, the assessment challenge that was taken up with the mother by every professional, together with those other aspects. And of course, the argument that's been put that what should have gone through at the welfare stage, if the father had been found to be a perpetrator, was just the father as perpetrator. Well, that would have meant, certainly on the facts of this case, as the assessment process is developed, that this mother actually became a risk and an assessed risk to J and indeed to W, but on those other factors rather than as a perpetrator of direct injury.
Yes.
So if I start at the, if you like, at the end of the local authority's case, it would be whatever the view of the law, however the mistakes have arisen, however much language has sadly caused such immense delay for these children, so that as at today there is no early certainty for them, that even if the court made a finding of perpetration of the father, it makes no difference to the orders Her Honour Judge Kushner makes. Certainly not to J, because it cannot, because of the operation of Section 31 and the proved harm, but also to W.
Could you help me on Section 41?
Section 31,
Sorry,
sorry.
31. Yes, I understand
Yes,
31.
so
Sorry,
Section
I thought it was
31.
41. Yeah.
Yes, but also on the likelihood of harm, which would be the issue for W, that the assessment conclusions, which I would say are not in any way tainted, in essence, because of the development of the issues, by a 40% and or cannot determine who was the perpetrator, that the threshold was passed for W, and once passed, all those welfare factors for J became applicable to W, notwithstanding that the mother did not, or evidence was not produced before the court in the final hearing that the mother had remained with the father. And the only other issue, because of course the appellant suggests this matter returns to parameter discussion. But one issue, practical issue that would arise if that was a consideration of this. Do the assessments start all over again? Or is it just that the assessments will be flawed? In this case, that what the judge said in her actual she was found not guilty.
Yeah.
And in reality, that's the only difference.
Well, where would you like to go from there?
I would like to start at the beginning, if I may, in terms of the law.
Yes.
And what appears to be the difficulty that arises from the lack of context in which previous decisions of the House of Lords have been taken, because they were deciding and dealing with different points and elements, some of which has already been raised in argument today. But Re-H and others, and indeed Re-B, were looking at how to prove harm and how to satisfy the, if harm cannot be proved, the likely harm condition. It is unfortunate, certainly, that expressions of likelihood, probability, possibility have been used in interchangeable ways and have caused the confusion. Take, for example, Lord Nichols says likely as in real possibility that cannot sensibly be ignored. That is in relation to satisfaction of the likelihood of harm condition. But real possibility becomes and is adapted in some of the other authorities to look at likelihood. Certainly when one looks at North Yorkshire, which I'll take you to in a moment, it is right to say that there is a test said to have been propounded by Lord Nichols through these cases of inclusion and exclusion based on real possibility. No such test actually exists in these cases, but it is taking the language of firstly Riech and others, and then using that language in what was a different context, and forgetting the link between H&R, substituted by Re-B on the one hand, and Re-O&N on the other. In the middle is Lancashire and A. And it's that that causes difficulty, because having established proved harm, so we're not in the case of harm that hasn't been proved, and what do you then do? The real possibility argument that was run in Re-B, which was set up by Mr. Justice Charles in terms of his I cannot find this, I cannot find that, was because of the outcome of Re-O&N, because of Lancashire and A. And so what Lord Nichols says in Re-O&N has very little to do with anything in terms of cogency or a degree of likelihood above or below the balance of probabilities. It simply is not the way in which those decisions developed. They have specific roles to look at specific issues that arose in terms of child protection difficulties. Because having found proved harm, the issue in Lancashire and A was, if I cannot identify which, and of course there were 3 people in Lancashire.
Would it be helpful to actually look at the case? I mean, you're not taking us as far back as 1996 and Rien, is it?
No, my lord. What I'm just trying to do is to give a snapshot of what those cases did,
yes,
and where they fit in to the development. And then what I do intend to take you to are those cases which would suggest that bits have been borrowed from each of those decisions to construct tests for inclusion, exclusion, and various other tests which have caused confusion. That this isn't a criticism of Lord Nichols, certainly not in O&N, but this is to do with the language and the different interpretation of something, likelihood, which, if we were simply using the Oxford English definition, would be probability, has actually different meanings depending on which aspect of child protection and which aspect of Section 31 the court considers.
Well, shall we find a starting point then, and then we can go through them one by one and just spot the differences?
If we start, firstly, with H&R,
Well, is that tab 12?
Yes, my lord.
So that is
tab
that is going back to 1996.
Sorry, yes, but it is only to look at, in particular, the use of likelihood and possibility.
Yes.
It is, I think, to make good the point I was making earlier.
It is.
Mr. Hayden, yes.
My lady.
This case is normally referred to by family lawyers as H&R.
It
because
is.
it was reported under that name in the family law reports. But of course, in the proper law reports, it's Re-H. We haven't even got the proper law reports here, but there we go.
Well, no, that...
Seems to be Re-H in the All England too, that's what we've got. Yeah.
Yes, it is.
So we're looking at the threshold condition for making the care order.
Yes. And having determined clearly that it was a balance of probabilities in terms of harm, the consideration also was likelihood of harm. And just bear with me one moment.
And do we go to Lord Nichols in this case, do we?
We do indeed. If you go to page 585, sadly, in the real reports, which I think...
We get proper report.
I don't think we've been allowed to have the real report.
No, we haven't.
But is it at 15? Do we start? Because we've got the All England references. You'll see they're intersected at various points.
It is. Thank you.
Where are we?
It's page 15, which is the issue of likely to suffer.
Do you have this? There's a heading at the bottom, towards the bottom of the left-hand page, likely to suffer harm.
It is. Yes, likely to suffer harm is on the facing page. And on the next page, part way down, before one sees a page entry of 16, on the right-hand side.
It's in the middle.
It's in the middle.
It wraps around page 16.
It does indeed. Likely is being used in the sense of real possibility, a possibility that cannot sensibly be ignored, having regard to the nature and gravity of the feared harm in the particular case. By parity of reasoning, the expression likely to suffer significant harm bears the same meaning elsewhere in the Act, and so on. Likely also bears a similar meaning for a similar reason in the requirement in section 31(2)(b) that the harm or likelihood of harm must be attributable to the care given to the child or likely to be given to him if the order were not made.
So he's exploring the meaning which you find in the statute, and now he goes on to examine what that leads to.
Indeed.
But he's drawing a very clear distinction between that and the standard of proof.
Yes, very much so.
Yeah.
Exactly.
But of course the local authorities case is that becomes completely admixed in a number of different authorities thereafter.
So you have to show on a balance of probabilities that there was a real possibility.
Yeah. Well,
it was more that if there were facts required in order for you to be able to establish the real possibility, well, then you had to prove those facts on the balance of probabilities.
yes.
And, of course, you had to prove past harm if that was your case. But this was a case of future harm on the basis of single allegation of sexual abuse, wasn't it?
It was. I mean, one of the difficulties, of course, is that, and it may account for the language that we see in Re B, is that Re H and R, known as Re H and others, and Re B, were dealing with an inability of a judge to find as a fact that sexual harm had been perpetrated on a child. And, of course, it's not always the case, but in most cases of allegations of sexual harm, the identity of the perpetrator is not, in fact, going to be significantly an issue. It's a question of whether the allegation against Mr. X is proved or not proved.
At any rate, the remainder of page 16, which is in fact the top of the next page before we get to the division to 17, we get his explanation of the standard of proof.
Yes, we do. And when assessing, if we go on to the standard of proof, just before where we go to page 17, that, of course, is Lord Nichols' what has been said to be the heightened cogency test. Balance of probability as standard means a court is satisfied an event occurred if the court considers that, on the evidence, the occurrence of the event was more likely than not.
Yeah.
And then when assessing the probabilities, the court will have in mind as a factor, to whatever extent is appropriate in the particular case, that the more serious the allegation, the less likely it is that the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probability. And of course that is the matter that was raised by leading counsel on behalf of the Guardian in Re B, and was said to have been causing difficulties in terms of identification of harm, which led to a critique of how it came to be that there might be said to be a heightened cogency test. Whether there is or isn't one, of course, depends very much on the individual judge. And one of the difficulties is that when a judge is dealing with fact-finding and is dealing merely with evidence, to a certain extent, some of the tests that have been propounded have caused additional difficulty. It will be certainly local authorities' general submission that the factual situation Mr. Justice Charles described would be highly unusual for a judge to find him or herself in. That it is much more likely in any given case that a route through to identification of perpetrator is obvious on the facts, if it is clear on the facts. That there are always those cases, and it generally is, the greater the level of deceit, the more confusion there is about access, probability, etc. and so on, the harder it will be for anybody to determine whether X has done. The reality is that most judges will not have, for example, been unable to find as a fact that harm has occurred using a heightened cogency test. Although it was suggested that it causes confusion. I wonder
whether, I'm sorry to interrupt you, whether we've obviously got a lot of exploration to do, whether it would be a convenient point at which to break and examine that problem tomorrow morning.
Indeed.
10:30 tomorrow morning.
Thank you.
But you're not attacking Re B.
Beginning to wonder.
No, my lord, my lady, I'm not attacking Re B necessarily, just exploring the difficulties that arise from what was the obvious protectionist stance for those reasons, and the issues that arise on identification of perpetrator. Certainly not balance of probabilities.
Thanks very much indeed. 10:30.